Good afternoon and welcome to the second episode of In the Trenches with Inventors, brought to you by US Inventor. I'm Natasha Ruckle, I'm your moderator, and we have an exciting hour ahead of us. If we bring up the agenda, you can see we have an amazing lineup of panelists, and then all of those panelists will participate in the debate, should inventors file for a US patent? So we absolutely encourage chat away throughout the whole webinar. And if you have questions, you can post them in there and our panelists will do their best to answer them. And we may even take some of those questions if we have time right at the end. But to start with, I'm going to introduce our host, Randy Landruno. He's an inventor with 3 patents. He's a former president and current board member of the Tampa Bay Inventors Council, and he's president of Complete Product Development, a firm that does CAD design, prototyping, and short runs. At US Inventor, Randy works with inventors across America, enabling a grassroots effort to restore the rights of inventors in America. So thank you, Randy, for joining us. Can you tell us a little bit about US Inventor and the goal of today's webinar?
Just a little bit about myself. I like many inventors, at some point in your life, most of us, we come up with a solution to something, and maybe we come up with more than one. At some point we think, well, wow, I'm an inventor, or I could be. What do I do about that? And they look into patents, and they look into the history in America and how America has been the innovator to the world, because we originally, from the very start, had a patent system that actually gave inventors the right to stop others from just taking what they had patented. It gave them ownership, real ownership of what they patented. And that's what led to America leading the world in innovation for a couple hundred years. And I was shocked to find out that big corporations, which it makes sense once you know about it, but basically big corporations have been working very hard for very many years to reduce the rights, the ability of an inventor to stop them from simply taking what you have invented and patented. And it makes sense, of course. They don't want to have disruptive competition. They don't want to be put out of business by the next great innovation. But you know what? It's that next great innovation that moves the world forward, and that's needed to improve the world. And it's needed to keep huge monopolies from controlling the world, right? It is disruptive innovation that is that is so necessary to progress of mankind. And of course, as we're going to talk about in this webcast, they've gotten some legal changes. The multinationals have pushed through legal changes that have made it virtually impossible to stop them from taking something something important and truly valuable that you have invented and patented, and you should own it and be able to stop them and be able to do something with it yourself, or maybe license it to them at a market rate if you want to. But if you want to have a startup that competes with them, you should be able to, because that's how America was built. And that's how those corporations started when our patent system was stronger as it was up until recent years. So anyway, the way US Inventor got formed was when, after we had lost the battle, I fought the American Invents Act, which we'll talk about here. That passed in 2011. But we lost that battle. And then only 2 years later, another terrible bill was about to pass the Senate. It actually passed the House in a landslide. It was the Innovation Act. Many of you probably don't know about it because we were able to stop it. It was as bad as the American Invents Act. And I found another inventor like myself, Paul Morinville, fighting it like I was. And we said, let's go to the Senate and let's talk to these people and let's stop it. And we were the first people on the ground. When we started fighting it, we were the only ones fighting it. And a lot of people just didn't know. And we were able to slow it down and to halt it. But then another Congress came in and it became a huge fight. And we had some allies by that point. But we were able to stop this thing. So, but the fight continues because big corporations have attorneys whose job is to weaken the patent system and make it so that the guy in the garage can't compete with them. And they're getting paid a huge amount of money to do that. And they're on the ground in Washington, D.C., maybe not right now, but normally they're on the ground all the time fighting this fight with false information and false narratives. And so US Inventor is here to fight that, to provide true information, to convince our elected representatives that, hey, this is an issue that is so important for America. American innovation is absolutely necessary. And now it's gotten so bad that we're in danger of losing out to other countries who are going to take the lead in key future technologies, because our patent system has been weakened to the point where real innovators are blocked. And other countries actually have stronger patent systems than us, including China when it comes to certain high-tech areas, which is amazing but true. So we have to fight this fight, and the purpose of this broadcast is that you can understand what's happened. These are real inventors who have been harmed by this broken system, and we need everybody involved in helping us change it and informing their representatives that, hey, this is a real problem that you need to look at.
Well, thank you, Randy. And I think US Inventor works really hard to help inventors protect their rights. And you're not alone. So thank you, Randy and Josh, and everyone who participates in making US Inventor such a great organization. So one thing that I think we should discuss, which will definitely come up in this debate today, is what is PTAB, Randy? Could you give us a quick overview, and why is it so bad for inventors?
Okay, so the PTAB is the Patent Trial and Appeals Board. It was created by the American Invents Act, which passed in 2011. It was sold to Congress by the lobbyists as a cheaper, faster, but fair alternative to district court for patent litigation. And it specifically is an easier way to invalidate an existing patent. And the truth of the matter is, it's not fair. For a big corporation that wants to invalidate, a big infringer who wants to invalidate a patent, oh yeah, it's cheaper and faster for them. But for the little guy who's trying to have a fair, have some due process in litigating real patent infringement, it's terrible. It is a killing field for patents. They have an 84% kill rate. Of the patents that have gone fully through the process to a final decision, 84% of them have been either fully or partially invalidated. They can hit you with more than one PTAB. You might, if you are able to get through one, they or another company can hit you with another. The more valuable your patent is, the more likely you will face the PTAB, and the more likely you will face multiple PTAB attacks until they destroy the patent. And it's expensive. Generally, in the neighborhood, the AIPLA said it was $400,000 to $800,000 to fight one. If you want good attorneys, you're talking toward the upper end. If you don't have money, you're going down, lower, and you have less of a chance. Either way, though, even the big guys get destroyed by the PTAB. And another key thing here, and I'll then go back to you, Natasha. For inventors, the average inventor in American history has not started out with a lot of money. Steve Jobs didn't have a lot of money when he started. Bill Gates didn't have a lot of money. The Google guys didn't have a lot of money. It always starts with one or two or a small group of individuals who typically have good ideas, but not a lot of money. And for them to fight one of these cases against a huge infringer takes a lot of money. And the way that it has been done historically is through contingency representation. That's where the attorney, you don't have to pay the attorney much, if anything, but they share in the winnings. And with the PTAB, it's become virtually impossible to get contingency because there's nothing to win from the PTAB. You're just trying to keep your patent from being invalidated. And they have such a high probability of eventually destroying the patent. So for the average inventor, they can't even get started, and they have no access to justice, and that is so un-American. So we're fighting to get laws passed, and to get, if we can't get laws passed, to get regulations made at the patent office that make this something that is at least slightly fair for the little guy.
Thank you, Randy. And I'd like to remind everyone that if you go to usinventor.org, you'll be able to see a lot of information that Randy has mentioned here today. Right, now it's my absolute pleasure to welcome our first panelist, Gene Dolgoff. He has 65 patents worldwide based on a variety of technologies. If you're a Star Trek fan like me, you'll be delighted to learn that because of Gene's holography work, he inspired Gene Roddenberry, the producer and creator of Star Trek, to create the holodeck. Now, Gene started working on what would become the LCD projector back in 1968. And while we don't have time to go into all of those details today, suffice to say that there was a lot of experimentation, many improvements. Earlier versions of that were patented, and then later those improvements were patented and licensed to companies like Sony, Samsung, Panasonic, Radio Shack, as well as several others. Now, this patented technology was the winner of $1 million prize in a DARPA contest for a technology to overcome Japan's lead in high-definition television. It's technology like this that allowed movie theaters to migrate from film to digital. And of course, Gene's technology is used in LCD projectors. I'd like to run a quick video right now.
They found other patents by other companies that had some similarity to some part of this. They said, well, you see this, all these different things. You just take all those, put it together, and we got yours. My innovation was to put all these different things together that didn't exist at the time and to add some new things that never existed. And they ignored that. They befuddled and confused these examiners on the PTAB who are not experts in the field that my projector is in, and fooled them into agreeing with them that it should never have been granted. So the PTAB then invalidated my claims.
And that was a snippet from the documentary Invalidated, available on Amazon. Right, so Gene, one of the largest and most successful patent litigation firms decided to represent you because they determined that the infringers probably owed you in the region of $1 billion. So with the biggest possible guns on your side, you went to the PTAB, Gene, but what happened then?
First of all, they didn't let me talk, so I had to be silent and only talk through my attorneys. So that was sort of working with your arms tied behind your back. But anyway, we went back and forth with the written documents that are required when you go to the PTAB. And the other side, the companies that were infringing my patent and were filing the IPRs, which are the petitions to try to invalidate my patent, they made arguments that were absurd. And just to give you an example, they would say, well, look, if you just take this prior patent and that prior patent and you combine them together, that equals one of your inventions. And so your invention is obvious. And what I said to them is, that's ridiculous because you cannot physically combine those two. And I even went so far as to show many different ways, actually every different way you could try to combine them. And then I showed how that couldn't work. And the result was the judges on the PTAB said to me, sorry, your argument is not persuasive. And the argument from the lawyers representing the infringers, that was persuasive. And that's just one example of the kind of nonsense that went on. But in every case, that's the response. Sorry, not persuasive. So the net result was the claims that I asserted were canceled. They were invalidated. And then I went to the appeals court, and the appeals court was actually worse because they didn't understand the technology at all. And they admitted it in the court, which we have on tape. They said, the judges there said, well, we don't really understand this. You could be right or you could be right. We don't know. And so what they finally decided was, we'll just let the PTAB decision stand. And they cited what's called Rule 36, which means this is our decision, but we can't give you a reason behind our decision, and we don't have to. So that's what happened.
So, and you had a really good attorney, right?
Yeah. Several.
And I know Gene is one of the rare cases where an inventor was able to get a PTAB trial on contingency because, again, they saw that this was worth $1 billion. And I wonder, this might be an attorney that would have cost 800 grand if they didn't take it on contingency. Do you think possibly?
Well, I don't know what it would have cost. It probably would have cost more than that. But I mean, I was hit with 6 IPRs simultaneously. So there was a lot of work that needed to be done. I mean, the amount of paperwork was unbelievable. And you know, if I had to actually pay those attorneys, the rates were incredible per hour because they were so good. But it didn't matter because the PTAB judges who don't understand the technology anyway were really hell-bent on canceling the claims. And so they just said simply, it's not persuasive, and canceled the claims.
So I would say with 6 IPRs, you're probably talking a couple of million, if not more, if you had to pay for it, which is what most inventors face, which is, it destroys them from the start. But the other question here is, so the PTAB judges, would you say that they didn't have anywhere near the expertise of the patent examiners?
Well, you know, the patent examiners are trained and they work specifically in the narrow area, which is why each area has a different number and a subclass. So when you apply for a patent, they select the examiner from a small number of examiners who are really experts at whatever it is that you invented. And that's after years of experience. So now it goes to the PTAB, and these are not examiners, and it should be. That should be who's involved in the PTAB, should be the examiners who originally worked on granting the patent. I mean, if you're accusing them of making a mistake, they should have the right to defend their decision, and they have the expertise to justify it. Meanwhile, these PTAB judges, who aren't really judges, and they are certainly are not patent examiners, and are certainly not expert in the particular area that your invention is, are the ones that are supposed to second guess what was done and say, we're canceling what you decided. It's totally absurd. It's illogical.
And for the listeners, so the PTAB, I failed to mention, there's no jury. There's a whole lot less due process. You don't have a real lifetime appointed judge. You have these, what they're called, anyway, they're APJs, they're called. And you don't have the due process. So in a real court, Gene, there would have been experts arguing back and forth that would have most likely been able to, you would have probably been able to successfully argue your case in a real court. Do you think?
Sure, especially if there was a jury. Yeah, but that's of course much more expensive, but then you have a chance because now you're not stuck to some inexperienced, quote, judges who don't understand the technology and who have an agenda to try to cancel your patent no matter what it is.
Hey, can I jump in, Randy?
Sure.
Hey, it's Josh. I appreciate you guys all. I mean, you've done a great presentation. I'm really thrilled to be a part of this. And Gene, what you've said, I think is really important because in the industry and in the public and even in the inventor community, there's this myth, and we've compiled several myths about the PTAB. And one is that they're experts, that we need technical experts to decide these complicated issues. So I just want to reemphasize for those that are listening that you've got to listen up for that myth that PTAB is experts, and remember what Gene just explained as to how they handled his technology. And Gene, can you just reiterate, please, how they fundamentally misunderstood what you invented?
Well, there's so many different things that happened. Another thing, for instance, was to solve the problem of brightness. I mean, that was a big problem. How do you make the projector bright enough? I had to invent a completely new optical component that never existed before. And so that was contained in my patents. And I called it a Fresnel polarizer. It was a name that I made up, and it had some aspects of what a Fresnel lens is. So I took the word Fresnel, and it also did something with polarization. So I called it a Fresnel polarizer. They then said, and when I say they, I mean the attorneys for the infringers, said, well, this is not an invention. Everybody knows what a Fresnel lens is. Everybody knows what a polarizer is. So this is nothing new. And I said, this is ridiculous. This is a brand new animal. This optical element never existed before. And I just coined that term. And of course, the APJs at the PTAB said, your argument is not persuasive. And so it's dismissed. And there was so many things like that. And it doesn't matter what logic you use. They have the right to say, not persuasive, and there's nothing you can do about it.
I'll just reiterate, they're not experts at technology, they're experts at word games. And so when you describe Fresnel polarizer, they're like, aha, I can combine a Fresnel lens with a polarizer prism, and voila, it's obvious, it already existed before. And so that's what I find in case after case, the vast majority of these cases, they're just mixing and matching words. Like I think in the famous, in the windshield wiper movie, the Robert Kearns Flash of Genius, he explains how in Shakespeare, you know, all he did was just combine words and letters that already existed. There's nothing genius about what he did. And that's really the main game that they're playing at the PTAB from my experience in hundreds of cases like yours.
Yeah, it's really a mistake to try to determine if a mistake was made in granting a patent by using people that are not experts at the particular technology that you've incorporated. They should be using the examiners, and most probably the examiners that actually made the decision to grant your patent in the first place. That should be the way it's done.
Well, you raised some very valid points there, Gene, and we're going to talk about the importance of patents and whether you should get one in our debate. So I'm looking forward to hearing your opinion on that.
Thank you.
Our next...
Let me say one more thing. I have some new technology now, which you alluded to and showed a little picture of, which is very advanced technology. And the question was, should I apply for a patent on it? And I did. And actually, I'm now going to be applying for patents all over the world, but including the United States. And one of the reasons is it is so new that there is no prior art. And in fact, the International Patent Searching Authority already completed their patent search on my claims, and they stated there's no prior art that demonstrates your claims, nor can any existing prior art be combined to anticipate or knock out your claims. And so therefore, you're going to have a granted patent on this. So I expect that's going to be the decision in the US as well as all the other countries. And hopefully, even if they do infringe, and even if I do sue them and then they go and file IPRs, hopefully they won't be able to find any prior art to knock it off. That's my hope, but we'll see.
Well, we'll keep our fingers crossed on that one, Gene, and hope no one infringes on that amazing technology that you've been creating. So I want to introduce our next panelist, Trae Smith. Trae has been involved with the women's fashion footwear industry for many years. He's been an owner of a company that produced and sold footwear products, as well as licensing products to others to produce and sell. Now, over the years, Trae got about 30 design patents, and more recently, he was awarded 10 utility patents. Now, various forms of lights and shoes have been around for about 30 years, but there's been little to no innovation in this area until Trae started working on it. What he developed and patented became the line called Firebug Shoes.
Firebugs is a collection of children's footwear that internally illuminates, the technologies of which include 6 utility patents, 2 patents pending, and more to come. Shoes with lights have been around for nearly 30 years, but those technologies have long expired, and there's been no innovation since. With Firebugs, our new patented technologies are positioned to lead the industry for the next 20 years and beyond. Intellectual properties are equated with big investment, but so is product development. Flip-flops where the entire upper seems to magically light up, and footwear of all types where the entire sole illuminates from heel to toe. And with all of these technologies, they include various methods for the internal illumination of graphics, logos, and designs. Plus, one of Firebug's newest technologies is the internal illumination of opaque materials.
Well, as you can imagine, this invention was a very big success from the start. But unfortunately, like many cases that we've seen, a large corporation chose to infringe rather than license. And when Trae tried to stop them, he ended up in 2 trials at the PTAB. So, Trae, thanks for joining us. What happened at PTAB?
Thank you, Natasha. First, I'd like to introduce you to my product, the light diffusing and internally illuminated textile footwear, which at one point in time, the patent office, specifically a patent examiner, believed that this was new, non-obvious, and a useful advancement within the art of footwear. This is a textile footwear. It is illuminated from an internal source, and it results in an ambient glow across the outer surface of the textile upper. In 2016, I filed suit against a Berkshire Hathaway company for patent infringement. and that matter was being handled on a contingency basis. And after nearly a year of litigation, Berkshire Hathaway filed an IPR, and within the PTAB, of course. And I will tell you that years prior, specifically the design patents that you had mentioned, I had always had very good results when it came to the enforcement of patents. But in early 2017, when these IPRs were filed, I had no idea, honestly, what an IPR was. I was surprised to discover this IPR, its costs and legal representation fell outside of the scope of my contingency agreement. Now, as you are aware, I am a small independent inventor, and my experience with the PTAB was a shocking reality I never believed possible in the United States of America. The IPRs filed against me by Berkshire Hathaway were instituted by the PTAB, meaning ruled upon and set for trial on the basis that my preamble and internally illuminated textile footwear comprises was not limiting. This despite federal case law, which establishes that preambles are in fact limiting. What they were doing, the PTAB, was allowing Berkshire Hathaway to reinvent my invention. So therefore, the PTAB's ruling meant that my preamble did not limit my claims to a textile. This was a very important victory for Berkshire Hathaway, in that their petition contained absolutely no prior art of any textile footwear where the textile components were internally illuminated. Upon institution, the PTAB adopted Berkshire Hathaway's definition of a shoe upper. That being anything, absolutely anything above the sole. Now, this is undisputable. There is absolutely undisputable evidence from textbook teachings and US customs, which states that an attachable component, such as eyelets, tongues, embroidery, bows, and other accessories, are not considered the upper. And that for a material to be considered the upper, that material must be suitable for use as a shoe upper. Now, here again, an important victory handed to Berkshire Hathaway by the PTAB, in that in order to invalidate my patent, Berkshire Hathaway needed the PTAB to rule that an attachable plastic window was in fact the upper of a shoe. Upon institution, these two rulings had transformed my light diffusing textile footwear into Berkshire Hathaway's prior art, which is right here. Figure 2 of Parker, a leather shoe with a light positioned behind a plastic window, which is a technology that has been on the market for over 30 years. Now, someone hearing this story might ask the question, well, is it possible that this could get any worse? Well, the truth is, yes, it did get worse. It got worse for me on appeal. And this is what is really unbelievable. The US Court of Appeals for the Federal District ruled that the PTAB did in fact error in its ruling concerning my 574 patent. The court, the US Court of Appeals, agreed with my argument that the preamble was in fact limiting. However, the court refused to remand the case back to the PTAB, stating that the PTAB's error was harmless to me, harmless. and my request for rehearing was denied.
So had the PTAB not gone ahead with their viewpoint that it was not limiting, then the PTAB case would not have gone forward. Isn't that correct?
If it would have gone forward, Berkshire Hathaway would have been forced to submit prior art with an internally illuminated textile. And there is absolutely no prior art of any type within their petition. And therefore, they had to persuade the PTAB that the preamble is not limiting in order to make their way to a plastic window being determined as a plastic window with a light behind it, of course, being the actual upper.
So the appeals court was right, yet they were very wrong in not having it go back to the PTAB. And we've seen problems with the appeals court often. It's pretty horrendous. I want to say one other thing. So to any of the viewers who don't know who Berkshire Hathaway is, that's Warren Buffett's company. So it's, you know, one of the richest men in the world, one of the biggest companies in the world. And it's a typical case where huge multinational corporation goes after the little guy, and everything is stacked in their favor, and it's horrendous.
So
Well,
can
a
I
caveat.
ask a
Yes,
clarification, Trey? This goes back to the same comment I had for Gene. So effectively, and by the way, your story is just, it's brutal. What you've gone through is completely outrageous, and it hurts. It hurts you. It hurts every other small business that wants to contribute to society. But in your case, it seems like they accused you of taking an LED and gluing it on the outside of a shoe, and you went to a lot of effort developing your technology and years in examination and starting a business and buying inventory. Isn't that pretty absurd that they accused you of just gluing LEDs onto shoes?
Well, what's absurd is this. The PTAB ignored my teachings, ignored the specifications. They ignored the commercial success. In the PTAB trial, not only did I submit affidavit of the commercial success, there were salespeople that were involved in selling this product that did the same. There were royalty reports submitted to the PTAB showing the royalties and the total pair that were sold. And there were multiple licenses. Now think about that. If this was not a new and novel product, why would 3 different shoe manufacturers license this technology from me? And that's exactly what happened, in addition to my own manufacturing and sales.
And just one final point on this, I know we need to move on. You're not trying to stop them from using the prior art, right? The prior art, they don't want to use the prior art, right? They're free to use the old stuff. You wouldn't sue them if they were using the old technology, but they don't want to use it.
No, absolutely not. I guess really a little bit of backstory. The specific brand that Berkshire Hathaway sold product on infringing this was Stride Right. Stride Right actually at one point in time employed me, and I worked for Stride Right, specifically the KEDS division. And knowing that our industry, that stealing of designs and technologies is prevalent, I approached Stride Right. We actually signed, and this is something else that the PTAB ignored and would give no weight to. I actually approached Stride Right and the possibility of licensing or purchasing this product, and instead they infringed. And shortly after the lawsuit was filed, Berkshire Hathaway closed Stride Right. Stride Right is now licensed to a different manufacturer and is basically a brand just sold in Target today.
It's terrible, and a reoccurring theme. Big companies with large money kill off the little guy. It's just not fair, and it's a terrible, heart-wrenching story. But thank you for sharing it with us, Trey.
Thank you.
Now, talking of heart-wrenching, we were meant to have Mark Kilborn with us today, but he's become unwell, so we wish him a speedy recovery. But we will have Randy telling his story because we feel it's an important story to tell, and we feel that he would like us to share it with you. But just to give you a little background, Mark Kilbourne is an accountant with a very methodical approach to things, and his father collected deadbolts. Mark started thinking about how to operate those deadbolts remotely. So he ended up inventing and patenting a device that fits onto any existing deadbolt and enables the user to operate it remotely. Quite a stunning product, I'm sure you'd agree. Well, we have a little video here that Josh actually filmed during that PTAB trial that Mark Kilbourne had to attend. Let's have a look at that video.
Just got out of the PTAB hearing, Apple versus Mark Kilbourne. Mark couldn't make it today. He unfortunately informed me a few months ago that he had a stroke. He invented the remote control deadbolt, so you can get in and out of your home now using your smartphone, your app. He shared it with one of their acquisition companies. Of course, Apple loves that technology. And rather than license from him, they took him to the PTAB. Matt Clements, working for Apple, attempting to take out a patent today by inventor Mark Kilbourne. Is this Matt Clements from Apple? Matt Clements is the PTAB administrative patent judge. He worked at the USPTO, canceled many patents. Matt, how many patents did you cancel when you worked for the PTAB? And then he went back to work for Apple. I tried to talk to him about that and ask him how much Apple's paying him, what sort of stock options he has. Hey, Matt, how much is Apple paying you? Matt, you got any stock options in Apple? Of course, he declined to comment. How do you respond to the allegations of conflict of interest, Mr. Clements? Matt, I saw you made an appearance for Apple today. You work for Apple at the USPTO? You work for the USPTO or Apple? How many patents has Apple canceled here today? Does Apple ever take a license to inventors without litigation? Certainly having to go through this and suffer the mental and physical anguish and the cost and expense of having to defend a patent that he earned from the United States Patent and Trademark Office is already an injustice. Matt, how did it go today? You think you invalidated Mark Kilbourne's patent? Have you ever met Mark Kilbourne?
Could you stop, please?
Have you ever met an inventor? Which side of the V are you on today? We'll keep working, guys. We've got a lot of work to do to bring justice back to this system and stop the abuse of inventors like Mark Kilbourne, corruption like Matt Clements and Apple, and the other cronies here at the USPTO.
Well, Josh does say quite rightly, there is a lot of abuse of inventors. It's not just monetary. The physical and mental strain is just horrendous. Randy, you're familiar with Mark's story. Can you tell us what happened when Apple tried to, infringe Mark's invention?
So and I also want to add something to what Josh said, and just to make sure the viewers all got this. So that particular PTAB judge was an attorney who represented Apple in infringement cases. Then he became a PTAB judge and helped Apple invalidate a large number of patents. And then he went back as an attorney, and that's where you saw Josh approaching him when he was, again, working for Apple as an attorney in front of the PTAB. What a conflict, you know? Anyway,
Randy, just to clarify, I can't remember the total number. It was close to 100 patents that this individual had invalidated, and on cases where where Apple was involved, he decided 23 out of 24 times in favor of Apple.
You know, you think about the revolving door, you know, in DC, and this is a perfect example, and it's all wrong. And it's terrible for the inventor, who is the one person who is supposed to have rights, as our Constitution says, regarding inventions. But anyway, Mark, as Josh said, he had some health problems. I'm not sure if it was a stroke or a brain aneurysm, but today he talked to it. I've been talking with him, you know, every day. And today I called him up to make sure he was ready for the webcast. And he had just spoken with his attorney about the appeal, and he was so worked up that he had to go to the hospital over, you know, he felt like he was having more bleeding in his brain. So there are numerous inventors out there who've gone through these cases and have experienced a huge amount of stress and anxiety. And I know Josh knows of others, and it's pretty horrendous. So, you know, we need to fix this thing. But anyway, what Mark invented was a device that you can operate remotely. And he actually first had it as just like had it with a key fob kind of a remote. But the thing about the device, you know, in other words, you don't have to take your deadbolt off. You just attach Mark's device to it. It's pretty phenomenal. And it was a big seller. He was doing quite well with it. And the Apple, where they probably first saw it, he's pretty certain, was at the big trade show, the Consumer Electronics Show, I think that's what it's called. Yeah, Consumer Electronics Show. Some Apple guys were there. And then when Mark decided to make an app that would work it, he worked, he was going to have to produce an app that would be sold at the Apple, App Store. And they wanted to see it. They wanted to see the invention. And of course, that's kind of unusual that they actually want to see this physical invention. In fact, people commented to him, well, that's kind of unusual that they want to see it. Well, of course, we know what they were up to. Soon thereafter, they had their own version. They definitely weren't interested in licensing from him. And when he tried to stop him, they took him to the PTAB. They found a piece of prior art that had some similarities, but there were key components that Mark had invented that the other patent didn't have, which is why the other patent didn't work. If you used the other patent to produce the item, you couldn't do anything with it. It wouldn't work. And Mark did some mechanical things, and I can't remember the actual. There were some terms like not a transmission, but the point is there were key mechanical elements he had invented that the PTAB judges did not have the experience to understand, and they basically were convinced by the attorneys for Apple that the other patent showed Mark's invention, and it was totally wrong. And it's another case where they didn't know enough. They didn't know enough to judge correctly, and he's on appeal now, and it's I don't know. I have the feeling from what happened this morning, it's not going so well. And of course, this is Apple we're talking about, a $2 trillion corporation. So how hard would it be for them to license an invention from an inventor that they're going to make a ton of money on? And of course, they apparently have a rule that they don't license anything, and they just take it. I don't know. Maybe it's in writing somewhere, but it's pretty horrendous. So anyway, we wish Mark the best, and hopefully maybe his appeal will come out okay, and hopefully his health will improve.
Thank you, Randy. We really hope that Mark has a swift recovery. Now, I wanted to introduce Josh, who has popped in and out of the discussion already. He actually quit his corporate job in 2006 to take his shot at the American inventor's dream. And 8 years later, after his savings were depleted and orthodontics in college unfunded, he took one last swing before drudging back to the corporate world. But he hit the home run with Bunch of Balloons. His solution to the 63-year-old problem of filling and tying water balloons instantly became the #1 selling spring-summer toy. It was just as quickly knocked off, and it resulted in a patent litigation, which now totals, and you can correct me if I'm wrong here, Josh, 6 patents, 5 patent suits, 5 PTAB petitions and trials, 4 preliminary injunctions, and 8 appeals at federal court. So Josh knows about PTAB and appeals all too well, and if you have any questions, you should definitely chat with him. Now, Josh spends most of his time working and fighting for inventors' rights. Now, saying that, Josh, I want to bring you into our debate, and I want to ask you, should inventors file for a US patent, seeing everything that you've been through?
Yeah, that's a very hard question. And of course, I had to have my patents, and we did fight it out, those of you that are familiar with my story. But let me just back up. I had no idea what was going on. Randy was working at this since at least 2010, maybe earlier. And I was busy. I was running a business. I was inventing things. I was trying to pay my bills. I had no idea what was going on in the patent legal space. But in 2006, the Supreme Court had issued a ruling in the eBay decision that no longer will inventors get to decide who can use their invention or how it's used. But instead, the judge and an economist will decide. And in 2011, of course, the American Invents Act created the Patent Trial and Appeal Board. And by the time I launched Bunch of Balloons, it was we were into the 3rd year of the PTAB, which is what we're talking about today. And they were invalidating over 80% of the patents that they were reviewing. And so, had I known this, so in 2015 was when I launched Bunch of Balloons, and I had filed my patents, and I licensed the product to Zuru, and we went to market, and then we ended up in this massive legal battle with telebrands. The thing is, though, that it was a huge gamble. Looking back at everything that had to go right for me to survive and to have that investment pay off, it's worse than playing the lottery. So my challenge with this question is, yes, I've been very successful and my patents played a role in this. But, should the lottery winner advise other aspiring lottery winners to spend all their paycheck and all their children's college fund every week on lottery tickets because it worked for you? And so that's my current situation, is that the system is so uncertain and so unfair. And we've heard several stories here today and several others last week, and there'll be more to come. I am a series of miracles is the reason that I was able to survive, and my patents did play a role in that. But at this stage, it's just it's worse than gambling because the cost is so much higher. Once you start down this path, the average cost to get a patent and pay the maintenance fees is $50,000. If you have to defend it once at the PTAB, that's $500,000. If you have to enforce it, it's $5 million. And all that can be multiplied by 10 or more if you're up against a big corporation that's determined. And I've seen too many inventors just crash and burn. You don't have those resources available to you. At this point in time, and Randy will talk about this, and we're working to fix that and level the playing field and make it so that patents can help legitimate inventors. But in the meantime, I don't recommend pursuing patents. I don't think it's a good investment.
Can I say something?
I actually want to ask Gene if you agree with Josh.
Yeah, I don't really agree totally with Josh, because it depends. If your invention doesn't have world-shaking potential, let's say it's just a small improvement and maybe you have a $1 million potential, that's something I would recommend patenting, because it's not worth it for the big companies to spend the money on the PTAB petitions and the lawyers if the win that they're going to get out of it is not that big. So I think if you have something that's not that earth-shaking, it would be worth protecting it with a patent. Plus, you need the patent to get investors to invest in your venture. They think that that's really great protection. They don't understand the PTAB and its dangers. But they insist, and rightly so, that you have filed and that you have a patent, because without that, everybody can copy it, and then you really have no market. So,
and I think, just to respond to that last point, I think that is the ground has really been moving underneath us in the past 2 to 3 years on that. When I licensed with Zuru, they didn't know anything about the PTAB, and they were happy to pay me a fair license royalty for it. But today, I don't think they would do that, because investors and companies are looking at that saying, how are we going to enforce these patents? And why would we pay an inventor 5 or 10% of our revenues when our competitors don't have that overhead? And so I think things have changed a lot in the last 2 to 3 years, and sophisticated investors and medium to large sized corporations don't see patents as collateral anymore for their investments.
It's true what you're saying, but if your product had tremendous financial potential, which was borne out by how well it's been doing. But what I'm saying is, if it's not anything big like what you did, then, or what I did, or many others, then it's not worth it for them. Then it's okay for them to pay a small licensing fee, because that's going to be the best financial decision for them. So it really depends on what the market potential is of what you've invented.
I want to say something real quick. What the patent is really, really needed for is, like what you said, what if you do create something that's really big that could change the world? If you don't have any patent rights, you can't do anything with it. And the vested interests that don't want to see it come out, because they are already doing what they're doing and making money off of that, they're not going to bring it out. And which is all the reason why we're here talking about this. Patent rights are so important to progress.
I'd like to ask Trey, what do you think? Do you think inventors should file for a US patent after everything you've been through?
Well, I think that first an inventor needs to realize that the rules governing the PTAB and the abuses which are allowed to take place within the PTAB, they are in stark contrast to our federal court system, Article 3 courts, and that these rules and abuses have in fact destroyed what was once the greatest patent system that had ever existed. Its reliability, predictability, reliance, and respect once held by innovators throughout the world. If an inventor knows this, watches programs as we are, in the backstories of various inventors as we're doing his today, I think that will be sobering. I'm not saying that a person should avoid the patent office and avoid our patent system, but they need to know the reality, and that is the reality.
When Fred and I invented our invention, the ripple rug, we were advised by a family member to go in and apply for a patent straight away. And I'd never heard of PTAB until actually I was introduced to Josh. So if I wanted to get an investor involved or even possibly sell the company, I would have to have those patents. And I open this up to all of you. Do you agree?
Yeah, you do. You have to have it, or you can't sell the company, or you can't get financing. It's just you have to have it. And so there's no question about it. And yeah, you might wind up having infringers who file petitions at the PTAB, but that's just a risk you have to take. Otherwise, you can't get involved in the game of inventing to begin with.
So I do have some authority on this, since we did win our case against Telebrands and we were able to collect judgment. I'm an investor now. I know lots of inventors, and they approach me about investing in their startup, and I haven't. Won't do it. Most investors now are telling them, well, how many IPRs have you survived? And then we'll think about investing in you. And so I don't think, yes, if that's all you have is technology, then number one, I would look at licensing it as a trade secret. Is this something that you can keep secret and find a partner? Even I know, Gene, some of the work you're doing, I think that could be locked up behind a black box and under secret. And you want a treatment for your cancer? Come use my machine. And that could have great value by protecting that trade secret. And there's other business strategies that, Natasha, to your question, you can use. You look at minimizing your capital investment. You look at getting a quick return. You look at being a serial entrepreneur where you get a product out there, bang, you make money for 6 months, you move on to the next one and let the copies race to the bottom. A lot of those strategies have to be considered in this environment, because expectation that you will have exclusive rights to your new, non-obvious, well-defined inventions is not a basis for confidence in a business plan.
What you just said is really true. The best position you can be in is if you file for a patent or multiple patents and you have trade secrets. That gives you the best leverage and chances of success. And that's very true. But, not all inventions or business models have trade secrets that can be kept secret. It really depends on whether somebody else could buy your product and reverse engineer it, and then your secret is out. So it really matters what your technology is.
I've been accused of being too optimistic, and we're fighting this fight to strengthen and restore our rights as inventors. So I would say, adding to what Josh said, one of the things that Josh did that was successful is don't just file one patent. File one patent, you probably want to do it on the fast route if you can, and have continuation patents probably on the slow route, so that as they invalidate your first few patents, you'll have other patents to fall back on. License it to a company, one that will stand with you and fight the infringers, as opposed to some companies that stand back and wait for you to get invalidated so they don't have to continue licensing from you. That happens a lot. But also get the thing making enough money as fast as possible so you have money to fight the fight. And the other thing is that provides you some time for us to hopefully restore the rights through regulations at the Patent Office, as well as legislation that we're working on both fronts. Also, don't just file in America. It used to be, oh, file in America, you're set. No, file in China if you can, and file in Europe, because you might get invalidated in America, but have valid patents left in China and Europe. So my advice would be, realize that it's not what it used to be. File and help us win this fight, because the thing stopping us right now is simply not having enough people far and wide across America behind this and telling their representatives and their senators that this matters. They're hearing from big tech that it doesn't matter. They need to hear from their voters that it does matter.
I think you all raised some great points. The doing a fast processing of your patent to get your first one out, I think, is a very important point that you raised, as well as doing multiple continuation patents that take longer to get to fruition. So that's definitely good advice. Josh, do you think there's any other strategies that inventors can employ other than getting patents to protect their invention?
I think the ones we covered, trade secret, quick to market, find a partner and lock them up with a really tight agreement. Yeah, I tell people, it's not the end of the world because your patents don't work. What would you do if you were an inventor in Venezuela where there's total corruption and no rule of law? You would find a way. We're creative, we're resilient, we manage. And so just be educated and go do what you can't help doing if you're an inventor.
Well, I just want to thank everybody for joining us today. Gene, Trey, Mark, I hope you get better soon. Josh and Randy, thank you so much for putting your input. Don't forget to everyone, go to usinventor.org, where we will post this video later on, as well as other valuable information and action items that you can take. And I would like to leave the last word with Randy. Thank you.
So thank you, everybody, for watching. And what we're fighting, this effort to restore the rights of inventors, is so important to the future of America. Without innovation, a few large corporations end up controlling everything, which is where we're headed now. And America was built on innovation and innovative small businesses. And innovative small businesses are the heart of this great country. And they're the key to employment. They help their communities. They use local resources. And this is what we are fighting to restore, the rights of the inventor and the innovative small business in America. And if we don't win this fight, America will just be like the rest of the world, and we'll lose the standards we have, standards of living we have. Future technologies that China and other countries are threatening to take the lead on, they will take the lead on if we don't unblock our innovators. So help us win this fight. Go to usinventor.org, sign our resolution, our inventor rights resolution, and keep up with us and stay updated and help us win this fight. Thank you.
I'd like to just add one thing to what you just said, Randy. The importance of having our patent system work like it used to goes even beyond that, because if you take away patents, you take away the incentive for lone inventors to go through the hell that you have to go through to develop your idea into a prototype and set up a company and get the product out there. And yet, in the old days, the patent system was that incentive. And so Americans came up with inventions and patents that have been so important to the structure of America and its dominance in the world, not only in commerce and in technology, but also in defense. We have the best technology to defend our country. If you take away the incentive and all those inventors say it's not worth it, and we start falling behind the rest of the world, we will be dominated, and instead of being the dominant power in the world, technologically, economically, and militarily. And then we really will lose our democracy in our country. So this is essentially important. What you are doing is just the most important thing for the U.S. technologically.
Thank you,
I
Gene.
agree.
Thank you.
Thank you, Gene. Thank you, everyone. Remember to check out usinventor.org.